Okay, what I have is calendar cleaned, now time for 3 o'clock motion hearings.
We kind of already did that, right? Once it's a dismissal, emergency continuance. Is Miss Jackson here?
Miss Jackson might be on Zoom. Miss Jackson, are you on Zoom?
Christina Ann Finnegan here, Your Honor, appearing specially, not generally.
Okay, we just have you in the system under Jackson, but that's perfectly fine. There you are. Okay, I can see you. Can you hear me all right?
Yes, much better than last time. I couldn't hardly hear you when I was in court the last time.
Get loud in here. Okay, so Miss Finnegan, you're on today for what we call a threshold hearing for 3-6, and I'll explain. What you've done is you've filed a motion to dismiss. The court rule for suppression and dismissal is 3.6. Threshold is there enough for your motion to go forward to a full hearing? The city has not filed a response, and my understanding is the city's not going to. Just going to defer to my making a ruling on Ms. Finnegan's motion. Is that a fair representation?
Yes, Your Honor. No written response.
Okay, so no written response. And Ms. Finnegan, I'll start by going down what you've got in your motion to dismiss, okay? The first issue you raised was a statute of limitations. The statute of limitations is the city has to file within the period of the statute of limitations. Our system allows for direct filing. Not the biggest fan of it, but it allows for direct filing by police officers, and it was filed within that time frame. So there is not a statute of limitations issue.
Excuse me, or I object.
Well,
I object. Can you please give me the date of when that took place?
June 3rd, 2015.
June 3rd of 2015?
That's what it looks like.
And the statute of limitations starts ticking on June 3rd, 2015. Am I correct, sir?
No, the date of alleged incident, which was June 2nd.
Okay, so we have June 2nd, correct?
Right, they filed it within 1 day, which is in the 2-year statute of limitations period.
And could you please explain to me what was filed on that date?
It looks like a direct filing by the officer, and I'm not sure if I'm pronouncing his name right, Officer Falconer, I don't know how to pronounce his name. Faulkner, okay. On June 3rd, 2015.
And direct filing means that there is no charging instrument with a sworn affidavit from somebody with firsthand knowledge. And am I correct, Your Honor?
Well, partly. There's not a charging document. The officer files the report, which is taken, and ticket, which is considered for probable cause purposes. And in essence, the citation, for lack of a better term, is the charging document. In Washington State, in district and municipal courts, a prosecutor does not have to file an information.
So a police report is a statement that can be based upon false or misleading statements.
Well,
because it is not first-hand knowledge. It is just a hearsay. As a former police officer, that was never allowed. When I testified in court many a time, that was unacceptable. Yes, sir.
That's the law, and that's my ruling. Okay. In terms of lack of subject matter jurisdiction, okay, it is a valid charging instrument. So these have an interplay that the officer files a police report under penalty of perjury, and the citation gives the court the proper subject matter jurisdiction to hear it. Again, I call it direct filing.
I
So-
object, Your Honor.
Well, I understand that. That's your motion, but
Thank you.
I've ruled on
I
that.
object.
Okay. Then all of this egregious governmental misconduct, and I'm just going through your brief, those are just conclusory statements. I don't have anything else, and I'll go through it, but what in essence is you're filing what is called a CRR 8.3B motion, but I don't have sufficient facts for that pertaining to the allegations on June 2nd, 2015. So I'm finding that doesn't meet threshold in this case. And so going through your statement of facts, for over 8 years, the state took no action. That's not accurate because the police are part of the state. They took action. They filed the case. Okay, you indicate on the night of August 24th, 2025, pulled over by Wenatchee police without cause. I think I don't know, but it's irrelevant to what I'm dealing with here, which is really, is there a warrant? And there was. And they executed.
Objection, Your Honor. Objection.
Okay.
Objection, Your Honor. I was arrested in 2015 and held. My daughter was arrested. She was not transported. I was arrested and put into Chelan County Jail for 3 days. No food, no water, no Miranda, and I was never transported to a magistrate or judge for finding a probable cause. So something seems to be amiss here in your record or the case file. I've never seen a case file either.
I'm going down your brief.
Yes, Your Honor.
You're saying on August 24th, 2025, pulled over by Wenatchee police without cause.
Yes, Your Honor.
Okay.
I'm addressing the process and procedure. The court never acted, Your Honor, in 2015. I was never brought to a magistrate. There was no finding of probable cause.
There was a finding of probable cause on June 17th, 2015. There was a finding of probable cause and a warrant was issued for $2,500. And that would
Your
be,
Honor,
ma'am, I gotta tell you, okay, I'll listen to what you have to say. I really don't like being interrupted. It's a personal peeve of mine. I let people speak, but if you're going to talk over me, I'm going to cut the hearing pretty short. So let me talk. Okay. So, and I'm going down your pleading. Probable cause was found on June, this is answering your question, was found on June 17th, 2015. It indicates that you did not show for your arraignment, and that's when probable cause was found and a warrant was issued. Okay? Then you indicate Officer Kate Abbott claimed to have a warrant but never produced one. They don't have to produce a warrant for a valid arrest. They have to produce a valid search warrant for search, but not an arrest warrant to arrest. Okay. Number 5, visible difficulty breathing and a heart condition. You were arrested. Again, I don't really have any say over that part. Denied prompt access to a magistrate despite the availability of night court. We do not have night court, so that doesn't apply. Your claims about what took place at the Chelan County Regional Jail are irrelevant to what's happening in this courtroom. And so that's just something you'll have to bring up independently elsewhere. Again, what happened at the jail, corrections officers, has no bearing on this charge. You posted bail, agreed. Released without being served any complaint, warrant, citation, or promise to appear paperwork. You would have been given your next court date for which you did appear. So that addresses that. The issues regarding bailiff impersonating himself as a clerk administrator have no bearing on this case. Your request for public records, I believe we directed you down to the police department if memory serves. And so that handles that. I don't know what court held a preliminary hearing that had been scheduled by bailiff with a third party. I don't know what that means. I'll ask you a question. When you say we had a preliminary hearing that was scheduled by the bailiff with a third party without your knowledge, what are you referring to on that, ma'am?
Your Honor, excuse me, please. I went to the court on August 26th with my daughter to see the court file and to get a certified copy of the court file. I had never been to the building, and there was no one at the window when I came in. And I went and I met the mayor, introduced herself, and then she told me that the clerk was there, and that if she wasn't there at the window, that she herself would help me. And I thanked her for that. And then when I went to the window, this man approached, and my daughter and I asked him if we could examine the file and obtain a certified copy of it. I handed him a paper requesting such, and he put some kind of a Post-it on it. And then he began to question my daughter. My daughter tried to give him her paperwork to put into the record as my durable power of attorney for health. And he said he didn't want that. And he reached around and back, and again, he started to question my daughter and I, insisting that he had spoken to my daughter. He had not. When I was arrested, Your Honor, a third party took it upon herself out of concern for my health. And
Ms. Finnegan, I'm sorry, something's come to my attention and I have to interrupt. I'm sorry, and I'll be right back to you, I promise, okay? And I'm addressing Pastor Robertson, okay? You can't record court hearings, okay? So if you could shut your phone off. Okay, thanks. It's all recorded anyway, so.
I got a bad hearing problem. At 80 years old, you have a problem sometimes. So
I get it.
That was the only reason.
I'll try and talk louder. We might, I don't know if our hearing thing works or not, or if we've got access to it.
what's the point?
Okay. So Ms. Finnegan, again, I'll ask your patience. Somebody else is on Zoom, perhaps? Can the other person on Zoom please identify themselves?
Hi. I'm Sophia Jackson. I don't know if you can see me. No, I'm just here helping my mother with the computer. We were having some issues with the Wi-Fi connection. So I'm just sitting nearby. I'm her power of attorney.
Yes.
I'm just here for technical support.
Very good. I'm assuming you're not recording this.
Oh, no, sir.
Okay.
No.
That's fine. So there shouldn't be anybody else on Zoom is what I'm hearing. There are other participants on Zoom not identifying themselves. Okay, I'll try one more. Do you have any idea who the other people on Zoom might be, Ms. Finnegan?
I don't know anything about the tech stuff, Your Honor. I'm sorry, my daughter does that, so.
Do you know if anybody else is appearing for this hearing on Zoom? Do you know? Did you hear me?
Are you speaking to me, Your Honor?
Yes. Are you aware of anybody else attending this hearing on Zoom?
I don't know how to do that, and I don't know how to check that, so
Okay.
I don't.
That's not my question. My question is, are you aware of anybody else appearing on Zoom, basically wanting to attend court, and they've appeared via Zoom? Do you have any knowledge of that?
I don't have any personal knowledge of any of that, Your Honor. I'm
Okay.
not.
That's fine.
Sorry.
No, that's fine. That's fine. I'm just trying to figure out who's on Zoom because our concern is they're recording a hearing. And these are already recorded in court. You can't record court hearings. And nobody's identifying themselves. Not you, somebody else is on Zoom.
Oh, okay. I just have my daughter with me as I have when I've appeared in court twice already.
Oh, you have names on there?
I'm showing a Ron Thompson.
Ron Thompson. Is there a Mr. Ron Thompson on Zoom? Could you please identify yourself? They're not going to.
I show a Rachel.
Rachel? Did those names mean anything to you, Ms. Finnegan?
No, not necessarily. No, Your Honor, I'm just here with my daughter.
Okay, well, that's fine.
Rachel gave a thumbs up.
Rachel gave a thumbs up. Okay. Rachel X, could you turn your audio on, please? I'm not getting anybody to respond. Okay, go ahead.
There's somebody by the name of Observer.
Somebody under the name Observer.
This is Rachel Thompson. I'm here.
Okay, very good. Thank you. Ms. Thompson, the court is open to the public and people absolutely can hear any court hearings, but they can't be recorded.
Understood. I am not recording, and neither is my husband, Ron Thompson.
Okay, very good.
He didn't know how to respond on this, the Zoom
Okay.
hearing. He doesn't know how to respond.
Okay, as long as I have your assurance you're not recording, again, court's open to the public.
Yes.
Media Feed 2.
Media Feed 2. Can somebody identify themselves as being part of Media Feed 2? Well, this is a first, Mr. Hoffman. On Bone Club, do I have the authority to disconnect Zoom if I have any reasonable cause to think they're recording? I don't know the answer to that.
I don't either, Your Honor. I would err on the side of not, probably. I think the court should order all people present to not record. And then if we get information that the order's been violated, then go from there.
Well, and I think as a matter of just sort of personal preference and policy, courts are open. So I'd agree with that. Okay, so anybody who is attending via Zoom, again, court's open to the public. Anybody can listen to court hearings, but I order everybody not to record and to please follow that order. Okay, Ms. Finnegan, sorry about the interruption. We were talking about when you were down here and
August 26th.
yes, and your brief says held a preliminary hearing. Well, we didn't have a preliminary hearing. We had a hearing on September 24th. There was no hearing on August 27th. So that addresses number 13. You appeared specially to contest jurisdiction. That's accurate. No prosecutor was present. No sworn complaint or probable cause affidavit was offered to the court. That's probably true. Let me look at the order setting case schedule. The city attorney was not, well, I don't honestly remember if the city attorney was here or not when I set the threshold hearing on September 24th. He doesn't sign the order because the order is for you. I'll ask Mr. Hoffman off the top of his head. Do you remember if you were here on September 24th? It was a court calendar day.
Yes, Your Honor. I believe I was, because I think I received a hard copy of the motion.
Ah, that's right. Okay, so the city attorney acting as the prosecutor was present. The probable cause affidavit was offered to the court back on June 3rd, 2015. And the court found probable cause and set a future hearing date. I actually didn't find probable cause. It was found on June 17th of 2015. So there was a prior court ruling, which I honor, and that addresses all of the points in your brief. So the bottom line is, Ms. Finnegan, is I'm denying your threshold, your motion at the threshold level, saying that this doesn't have a legal basis to go forward a full hearing on the order of dismissal. And what we need to do is we need to set dates.
Objection, Your Honor. I would like to state that I was arrested after June 17th, 2015. It's my daughter. And I was not brought before a magistrate. I was never shown a warrant, and I was never provided any court date to appear, and bail was set. I was released to my daughter's care.
And I've addressed all of those things, Ms. Finnegan.
I don't see where you have addressed an arrest of myself after June 17th, 2015, Your Honor. There was no probable cause found then. I was not brought before a magistrate for a determination of probable cause.
Ma'am,
And
probable cause? Go ahead.
Yes, thank you.
Probable cause was found on June 17th, 2015, and a warrant was ordered.
Why wasn't I brought before the court, Your Honor? I was
You didn't
arrested
show up.
and I was at Chelan County Jail. No, Your Honor, I was arrested and placed in Chelan County Jail after June 17th, 2015. I'm working on the
Because you-
public record request that you had suggested that I do, and I'm hoping to be able to obtain all those records for you, but I was in jail for 3 days.
Because, ma'am, I
never
think you
saw a
bailed
warrant.
out before.
I was released. No, there was no.
I'm trying to answer your questions, ma'am.
Thank you. You cut out, Judge. The computer cut out.
Okay.
There's a delay.
Okay, I believe you bailed out before your court hearing. So we set another court hearing with your being out of custody.
No bail was set, Your Honor. I did not pay any bail. I was released without bail, without paperwork, never, and I was told there were no warrants. And I'm working on obtaining those records for you. But I do have my daughter present who was arrested and not transported, but she was threatened and told that she was going to be brought to juvie
Okay, ma'am,
as an adult,
ma'am,
woman.
let's focus on one issue at a time. Okay?
Okie doke.
Okay.
Thank you.
It looks like you were arrested on August 25th, which was a Monday.
Objection, Your Honor. I was arrested in 2015 after June 17 and kept in Chelan County Jail for 3 days. Actually, the corrections officer's name was Kennedy, a female corrections officer named Kennedy, released me and told me there were no warrants.
Okay, so going back to that time frame. A warrant was quashed. Let's see. A warrant was issued on June 18th, 2015. From the old minutes, it would appear you were arrested on July 16, 2015. You refused to be fingerprinted and into jail and refused to appear. So the case was set over to Monday. That was an arraignment on July 20th, 2015. And then the only notes in here is simply defendant no longer in jail. Then on
Your Honor, the
August,
court has paperwork showing that the court's jurisdiction has been invoked. I don't understand this timeline, which is why I'm hoping to obtain, all of the records through the public records request. But I'm sorry, I was trying to take notes as you were speaking. You had mentioned something about July 16th, and then would you mind repeating so I can make sure I have this down correctly? And then something about July 20th?
it appears to the best of my interpretation of the court record, and ma'am, I'll tell you, I don't think any of this is relevant, but You were arrested, it looks like, on July 16th, 2015. You refused to be fingerprinted and to show up at court on July 17. Court was set over to the following Monday, July 20th, 2015. And at that point in time, you were no longer in jail. I don't know.
Well, how did that happen?
Ma'am, I'm just telling you what the clerk's minutes say. I wasn't the judge in 2015. And then you missed.
But you did mention that a warrant was quashed, Your Honor.
I'm just reading the clerk's minutes, ma'am. Okay. So then there was an arraignment on August 19th, 2015, and a warrant issued because you didn't show.
Do you have a record of notice of hearing or anything for this August 19th date?
Your Honor, can I interject for a minute?
Absolutely.
So my suggestion is the way these hearings go is the party who writes a motion writes down their arguments. They get an opportunity to make oral argument. The other party gets an opportunity to make a written response and an oral response, and the court makes a ruling. We've been through that. She made a written response. The court gave her ample time to make oral argument. The city chose not to provide a written response. The court went through and ruled on threshold, which is the point of today's hearing. The kind of Q&A that we're getting into with the court and the defendant, I think
It's far afield.
it is. And I understand that the court is trying to answer her questions, and I think
Yeah.
hopefully she appreciates that. But we're not getting anywhere. So the point of today was for the motion hearing. Threshold has been denied. I would suggest we set another date for a status or pre-trial. And then Ms. Jackson can attempt to get in touch with me.
Miss Finnegan, I correct you, sir.
Okay. Either way, the
No,
defendant
misnomer. Jackson is a misnomer.
Okay, Miss Finnegan or Miss Jackson, again, I'm a little tired of the interruptions, okay? He's identifying you as you have been charged. We'll use them interchangeably. Understand, 80% of this conversation is just simply because we're being nice. I've ruled on the motion and we're going to set dates, and I'm just trying to be nice and helpful, but we're kind of done now. So, with that, we have speedy trial expiring December 9th, 2025. You, I believe, want to continue going forward pro se, representing yourself. Is that accurate?
Yes, that's correct, Your Honor. Can you please tell me what grounds you're denying motion?
I did. I went through it. I went through your brief line by line, and I'm done ruling on that. So, with speedy trial of December 9, and I don't get the feeling this is going to resolve short of trial, I'm ready to just set dates.
Your Honor, I respectfully raise an exception to what appears to be reversible judicial error. Nothing personal, Your Honor, but this needs to be reviewed. That's all.
Well, ma'am, you can appeal it when the case is done in municipal court. But you do it at the end of the case. Okay, so with speedy trial expiring December 9th, 2025, and I believe Ms. Finnegan wants to continue to represent herself, what we do is we always set a trial date with a backup date. So the trial date that I would propose and probably stick to is November 20th. A readiness.
Are you saying?
Yeah, go ahead.
I'm sorry, Judge. No, you're changing the speedy trial date that you gave the last time?
Your speedy trial is December 9th, 2025. You have a right to a trial by then. Okay.
Thank you.
With that, I will set a trial date of November 20th, so it is within your speedy trial rights. we'll set a readiness hearing on November 5th and maybe 2:30. 2:30 in the afternoon, work with your schedule, Ms. Finnegan.
I'd have to check. It's dependent upon my health as well, Your Honor.
Well, I'll set it for November 5th at 2:30 unless you ask for a different time right now.
It doesn't give me time to obtain discovery or anything, Your Honor.
Well, then
I don't have the facts that are needed in order for me to launch a proper defense for myself, sir.
okay, so Ms. Finnegan, if you're not ready to go forward on November 5th, then what you would need to do on November 5th is waive your right to a speedy trial and ask for more time. Which is fine, but we're not going to do that today.
I guess for the record, Your Honor, too, I haven't received a request for discovery.
Right. So Ms. Finnegan, you also need to make requests for discovery to the city attorney for anything pertaining to this case. And public records request, you need to go to the police department down on Simon Street.
Yes, Your Honor, I've already done that.
Okay,
Thank you.
very good. Okay, November 5th, 2:30 for readiness. November 20th, 8:30 in the morning for trial. If you want more time to prepare and so forth, then we'll address it on November 5th.
I don't know where she lives. My preference for readiness is that parties be present, because if we're going to summons in a jury, I'd like to know that they're like within the state or planning on actually being here.
And Ms. Finnegan, where do you live? Did you hear me? Where do you live, Ms. Finnegan? What city?
Wenatchee, Judge.
Okay,
I've been
very good.
in Wenatchee for some time.
Well, because if you've moved or something, then I take that into consideration when ordering people to either appear in person or Zoom. But on November 5th, you need to be here in person, ma'am, for several reasons. It's readiness. 2, if you're going to waive speedy trial, we'll have you sign a document and hand it forward so that it's in writing. And it's just one of those hearings where you need to be here in person.
If my health allows, Your Honor, of course I'll appear.
Okay. Well, I would need some sort of proof as to why you can't appear in person, and we'll deal with it on November 5th.
Are we going to, does she have my contact information? Is that going to be on the paperwork that we send her?
We're going to include Mr. Hoffman's phone number. He's the city attorney. And his email address. So the two of you can work through this case.
We also offer Ms. Finnegan, she can be appointed standby counsel if she wants. Can we
Well,
offer that to her, I guess, Your Honor?
the city attorney is inquiring as to whether you would like the assistance of standby counsel or the assistance of counsel to work through this case.
Not at this time, Your Honor. If I do, I'll be able to tell you that.
Okay.
Sure. Although, sure, I guess where you said for standby.
They can guide you through the process.
Oh, sure.
Okay. What is your income, ma'am?
0, Your Honor.
Okay. So I could find that you're indigent. Who should we appoint? We're going to appoint Mr. Yednak. You're going to get his name and number, just included on there. What? He's not here. Oh, he is here on November 5th. He's not here on November. No, he's here on November 5th.
Yeah, he is. Mr. Melton is not.
Right. We're going to appoint Mr. Yednak to assist you, and we're going to put his name and number on the scheduling order we're going to send to you.
You need.
Understood, Your Honor.
And we need to know how to send this to you. Do you have an email or how do we get you this order?
The email has been provided to Mr. Hoffman and to the court already, Your Honor.
Anybody have it? We'll check.
Not sure how was it provided to me?
Do you remember how you provided it to Mr. Hoffman?
Yes, Your Honor, email, not, excuse me, yeah, it was e-filing. My daughter helps with all the tech stuff, and, so she helped arrange that. And,
We don't have. I don't think Mr. Hoffman has it. Could you give us your email address so he has, so that we have it, so we also know how to provide you things?
absolutely, the clerk administrator also has it, Mary Beth Phillips. It is cafinnegan@protonmail.com. And I did email my motion for a remote Zoom hearing to Mr. Hoffman, and I did have a confirmation on that as well, Your Honor, that it was received by him. That was October 17th, I believe.
Okay, so C.A. Finnegan at What is it?
Protonmail,
Proton
correct,
mail.com.
correct.
Okay.
And just to clarify, Your Honor, so that she doesn't have the wrong email or something, I did not receive an email from her on the 17th. Did not confirm an email either.
Well, I do have a confirmation on my end, and I don't know what to say about tech errors or tech problems from from where you're located, Mr. Hoffman. So I only can say that I have confirmation.
I'm out of the loop on this. Okay, we will send your dates, Mr. Yednak's phone number, and Mr. Hoffman's contact information.
Excuse me, Your Honor, there was one thing I wanted to, when there was, when you were talking to other people, I didn't get to state something that I would like to state for the record, that on August 26th, when I was with my daughter, she handed a document to be placed into the record, and it wasn't placed into the record. And I just wanted to state that that took place.
It's okay. It's on our record.
Thank you.
Okay, we'll see you on November 5th.
Thank you, Your Honor.
Yep, that'll conclude it. Okay, and that's everything I have on the calendar. Okay, on to the 2:30s. Is Christina Jackson or Christina Finnegan on Zoom?
Yes, I'm right here, Judge.
Very good, ma'am. Ma'am, my understanding is the city is going to go ahead and dismiss these. And so I don't need to address the stuff that you've submitted to the court earlier today. That'll just end the case. Is that accurate, Mr. Hoffman?
Yes, Your Honor. So city is making a motion to dismiss on 5Z06-75620 and 5Z06-75621. The motion to dismiss is based on the age of these cases. They're from 2015. We have some evidentiary issues, just given the age. The motion to dismiss is not based on any of the legal motions. So I've got an order here that is a dismissal without prejudice. It's been signed by her standby counsel.
Okay, so do you understand that, Ms. Finnegan? The city has moved to dismiss. It just ends these matters.
Thank you.
Okay, any conditions, anything are removed, and this is over.
Thank you, Your Honor.
Take care.
Are you gonna
Okay, and I think that's the only one I have on Zoom, right? Yeah, okay, thanks, Ms. Finnegan.